In the early hours of 23 December 2025, Buckingham Palace released a statement that left almost no room for interpretation and zero space for negotiation. After nearly 4 years of intense litigation, repeated appeals, and highly public confrontations, Prince Harry's legal battle to restore taxpayer-funded police protection in the United Kingdom came to a definitive end. The Court of Appeal upheld its previous ruling, confirming that the Duke of Sussex would not automatically regain state-funded security when returning to Britain. Within hours, the palace moved decisively in a rare and carefully orchestrated intervention. King Charles III framed the ruling not as a personal defeat for his younger son, but as a constitutional clarification, one that, in his words, the monarchy could no longer delay making. The statement brought necessary finality. It reaffirmed that royal status cannot exist independently of royal responsibility, and that public resources must always be governed by fairness, duty, and service to the nation. For the first time since Harry stepped back from royal duties in 2020, the institution publicly confirmed what critics and constitutional scholars had long argued: royal privilege cannot survive separation from royal obligation. The ruling marked the conclusion of a legal campaign launched by Prince Harry in 2021 after the Home Office confirmed that UK police protection would only be provided on a case-by-case basis. Following his exit as a working royal, Harry insisted that the decision exposed his family to unacceptable risk and amounted to unequal treatment. The courts disagreed repeatedly. On 23 December, the Court of Appeal found that the government had acted lawfully, proportionately, and entirely within established national security frameworks. Crucially, the judges reaffirmed that there is no automatic entitlement to taxpayer-funded protection for non-working members of the royal family, regardless of lineage or prior service. The judgment explicitly rejected claims of procedural impropriety and found no evidence that the royal household had interfered with judicial or security assessments, allegations Harry continued to raise publicly. The palace statement went further than simply acknowledging the court's authority. It reframed the outcome as part of a broader institutional reset. Following years of reputational strain and challenges to public trust, the king declared that the crown must be seen to act with consistency and integrity. No individual, no matter their birth, can retain national privileges while refusing national duty. The language was deliberate after a decade marked by internal divisions, public disputes, and the commercial exploitation of royal association abroad. The monarchy sought to reassert itself as a public institution, not a private inheritance scheme. Senior aides described the moment as a necessary boundary, drawn not against a person, but against a precedent that risked eroding the very logic of constitutional monarchy. Yet even as the legal process concluded, Harry showed no sign of reconciliation with the outcome. Speaking from California, he reiterated his belief that security concerns for his wife and young children justified continued state protection regardless of official status. He further implied, without evidence, that palace influence had shaped the environment in which his appeal was assessed. This posture confirmed a long-held concern. The Duke appears to be seeking the protections of royalty without the constraints of service, while simultaneously rejecting the accountability that accompanies it. Officials privately noted that Harry's children have never returned to the UK in any royal capacity, nor has he proposed a framework under which his family would resume official duties. In this context, security has become not a prerequisite for service, but a substitute for it. At the heart of the dispute lies a constitutional reality that Harry's legal team struggled to overcome. The British monarchy is not merely a family legacy, it is a national institution underwritten by government authority and public funds. Police protection is not a ceremonial courtesy. It is a national security function funded by taxpayers and justified solely by public interest, as the Home Office made clear in court. Extending such protection without a corresponding public role would undermine both precedent and accountability. In that sense, the Court of Appeal ruling aligned precisely with the palace's position, aiming to prevent misuse, perceived or real, of national resources for private or commercial ends. By midday on the 23rd of December, it was clear that this was not merely the end of a lawsuit. It was the formal closure of an era in which ambiguity allowed grievance to coexist with privilege. The monarchy, bruised by years of internal conflict, chose clarity. Put bluntly, one senior royal source said, "The institution cannot be asked to subsidise separation." If Buckingham Palace believed the Court of Appeal ruling would close the chapter, Prince Harry's response ensured the opposite. Within hours of the judgment, sources close to the Duke confirmed that he regarded the outcome not as a legal conclusion, but as a moral failure of the system, one he insists was shaped by forces beyond the courtroom. From California, Harry reiterated a familiar claim. The withdrawal of taxpayer-funded police protection placed his wife and young children at unacceptable risk, and without guaranteed security, a return to Britain, even for limited engagements, was impossible. Yet he did not outline any concrete plan to resume royal duties, nor offer any proposal to accept the institutional constraints such duties would entail, a detail palace officials consider decisive. This omission makes the dispute far more than a debate over logistics. Instead, it has become a case study in reverse logic within the traditional constitutional framework. Security follows service. In Harry's argument, service is deferred until security is restored. Senior aides described this as an untenable inversion, one that would allow a former working royal to negotiate public privilege from outside the institution without committing to responsibilities. This inversion, they argue, explains why the Duke's legal strategy persisted even after repeated judicial setbacks. The issue was never merely protection, it was leverage. Central to Harry's public narrative is the welfare of his children. Yet palace records confirm a blunt reality. Harry's children have never returned to the United Kingdom in any royal capacity, nor have they been introduced to the institutional structures that define royal life. From the palace's perspective, the children's argument functions less as a logistical concern and more as a rhetorical shield, placing emotional pressure on the institution. While avoiding reciprocal obligation, the absence of security is presented as the barrier. One senior courtier noted, "There has never been a plan submitted for service, representation, or even presence." This contradiction is sharpened by the Sussexes' commercial activities in the United States. Over the past several years, Harry and Meghan have built media, publishing, and entertainment ventures that explicitly trade on royal identity, while simultaneously rejecting royal governance to the palace. This dual posture, distance from duty paired with proximity to brand, has steadily eroded trust. Repeated warnings were issued privately. Multiple sources confirm that Harry and Meghan were cautioned against blurring institutional credibility with personal monetization, especially when national symbols and titles remained central to their public persona. Those warnings, however, went unheeded. What frustrates senior royals the most is not dissent. It's delay. The palace believes Harry has deliberately stretched the conflict through litigation, appeals, and media interventions, not to resolve the matter, but to keep it alive. Each extension prolongs ambiguity. Each public statement reframes legal finality as personal injustice, and each allegation of interference, despite judicial rejection, fuels public mistrust. From the palace's standpoint, this approach is corrosive. It destabilizes constitutional norms, undermines the courts, and recenters a private grievance within a public institution charged with safeguarding national order. Notably, key senior figures have refused to engage publicly. Prince William, Princess Anne, Prince Edward, and Catherine have all maintained disciplined silence. Palace insiders say this restraint is intentional. It reflects a shared understanding. Authority is preserved through process, not rebuttal, and the court's judgment speaks louder than any counterstatement. Behind closed doors, the verdict was said to be unequivocal. Privilege divorced from service is not reform, it is erosion. By late evening on the 23rd of December, the positions on both sides were unmistakable. The courts had ruled, the king had spoken, and government policy aligned with both. Harry, however, remained unmoved, continuing to frame the outcome as persecution rather than precedent, and treating institutional boundaries as negotiable. For the palace, this confirmed a hard reality. Reconciliation cannot occur where responsibility is refused. Behind the palace's composure and Prince Harry's persistent protest lies a legal architecture far more rigid than personal grievance allows. By the time the Court of Appeal issued its final ruling on the 23rd of December 2025, the dispute had already been stripped of sentiment and reduced to constitutional fundamentals. Who qualifies for state-funded protection, on what basis, and under whose authority? The court made one thing crystal clear: entitlement does not hinge on bloodline. At the centre of the judgment is a principle often misunderstood in public debate. Police protection funded by the British taxpayer is not a royal perk. It is a national security function administered by the Home Office, assessed through specialist bodies tasked with balancing risk, public interest, and proportionality. The court reaffirmed that the Royal and VIP Executive Committee operates within this framework, not as an extension of the monarchy, but as a state mechanism. Its mandate is to protect individuals only when a clear public role generates a public risk. In Prince Harry's case, that link no longer exists. The Court of Appeal rejected the claim that Harry's former status as a senior royal created a permanent state obligation. Judges concluded that his decision to step back from royal duties constituted a material change in circumstances, lawfully justifying reassessment of protection. Crucially, the court confirmed that the case-by-case model offered to Harry was neither punitive nor discriminatory, nor procedurally flawed. In fact, it mirrors how the UK treats all non-working public figures, regardless of fame or past service. Harry's claim that he was uniquely singled out could not withstand scrutiny. One of Harry's most damaging assertions, that the royal household exerted improper influence over security decisions, was addressed directly by the judges. After reviewing classified and redacted materials, the court found no evidence of unlawful interference or manipulation. The mere presence of palace officials within advisory structures, the ruling noted, does not equate to control. Their role is consultative, not determinative, providing context rather than instruction. Legally, the allegation failed entirely throughout the appeal. The government consistently argued that restoring automatic protection would undermine precedent and create openings for claims from former office holders and public figures, including non-working royals. Officials warned the court that granting Harry's request would effectively transform security into a portable privilege untethered from public service. The judges agreed. The ruling emphasised that once the state allows protection to follow personal preference rather than public duty, it ceases to be defensible as a national expense. Far from resisting the outcome, King Charles III quietly aligned the monarchy with the court's logic. Palace sources confirmed that the king viewed the judgment as a necessary reinforcement of institutional discipline, shielding the crown from accusations of favouritism or impropriety. This alignment was deliberate. After years of scrutiny over royal neutrality, Charles opted for constitutional clarity over familial ambiguity. The message was unmistakable. The monarchy does not stand above the law, nor bend it for itself. Perhaps the most consequential aspect of the ruling is its finality. By upholding Home Office discretion and rejecting claims of procedural unfairness, the Court of Appeal left no viable pathway for reinterpretation. Any further appeal would require the Supreme Court to overturn not only factual findings, but also the underlying logic of national security governance, a prospect legal analysts consider implausible. In effect, the door has been closed not by the palace, but by the Constitution itself. What began in 2021 as a personal challenge had, by December 2025, become public precedent. The courts drew a line between service and separation, while the government insisted that national resources remain accountable. Harry may continue to argue that safety demands exception, but the law has concluded otherwise. While the courts delivered legal finality, the real consolidation of authority occurred behind palace walls. In the days following the Court of Appeal ruling, senior royals closed ranks, not with public confrontation, but through coordinated restraint. The message was unmistakable. The era of ambiguity had ended, and the monarchy would now be governed by order, not accommodation. At the centre of this consolidation stood Princess Anne, known within the institution as its most uncompromising custodian of duty. Anne's influence was decisive. Palace sources describe her position as unwavering. Royal status is functional, not sentimental. To her, the security dispute was never about family estrangement, but about precedent. Anne argued that granting exceptions, particularly after repeated refusals, would signal that persistence, not responsibility, determines entitlement in an institution built on continuity. That logic was intolerable. Her stance shaped the internal consensus. Service defines legitimacy. If Anne provided the doctrine, Prince William embodied its future as heir to the throne. William deliberately refused to respond publicly to Harry's allegations, a silence Palace insiders describe as strategic, not emotional. William's view, according to those close to him, is that institutions do not argue with individuals. They act, document, and endure. The Court of Appeal ruling provided the institutional answer. Anything further would reduce authority to spectacle. His approach signals the monarchy he intends to lead, one that privileges governance over grievance. Less visible but equally firm has been Prince Edward, whose role within the working monarchy centres on operational discipline. Edward supported the government's case throughout, emphasising that security policy must be uniform, not tailored to personal history. From Edward's perspective, the danger lay not in denying Harry protection. Rather, it was in normalising entitlement without obligation, a principle that, once eroded, would destabilise every future decision involving public resources. Perhaps the most powerful symbol of the monarchy's posture has been Catherine. She has made no statements, offered no rebuttals, and engaged in no narrative correction. Instead, she has continued her public work, projects centred on early childhood, community resilience, and mental health, without pause. Within the palace, this silence is understood as deliberate. Where conflict seeks attention, continuity restores confidence. Catherine's constancy reinforces the institution's claim that service speaks louder than accusation. Importantly, palace officials stress that the position taken against Harry's demands is not punitive or emotional. It is collective, procedural, and institutional. Every senior working royal has endorsed the principle that national protection cannot be detached from national representation. Discipline replaced disagreement. Past crises had been fueled by family divisions that stoked public doubt. This time, senior royals demonstrated unity and clarity. The calculus was stark. To concede would mean teaching the next generation that duty is optional and entitlement negotiable. By the evening of 23 December 2025, the internal position was settled. The courts had spoken, the king had aligned with the law, and the senior royals had closed ranks around a shared doctrine. The monarchy survives by rules, not relationships. With the courts closed and the palace unified, attention shifted west, toward California, where Prince Harry and Meghan Markle continued to frame the ruling not as legal finality, but as institutional injustice. Their responses were consistent in tone, disappointment edged with defiance, a refusal to acknowledge precedent, and insistence that the matter remains morally unresolved. To the royal household, this posture confirmed a belief long hardened over time. The conflict is sustained by choice, not circumstance. In the days following 23 December, statements from the Sussex camp emphasised safety, children, and betrayal. The message was familiar. Without guaranteed state security, Britain remains off limits. Without Britain, reconciliation is impossible. Yet conspicuously absent from these responses was any acknowledgement of the court's reasoning or acceptance that public protection follows public duty. Instead, the ruling was recast as systemic bias and royal indifference. Palace officials see this reframing as deliberate, transforming a constitutional decision into a personal slight. The Sussexes preserve a narrative of exclusion that continues to resonate with sympathetic audiences abroad. Meanwhile, Harry and Meghan's commercial trajectory in the United States has remained uninterrupted. Media partnerships, speaking engagements, and content production continue to leverage royal association, subtly reinforcing the status they claim to have left behind. This duality, distance from duty paired with proximity to brand, has long unsettled senior royals. According to palace sources, repeated warnings were issued between 2021 and 2024, cautioning against the sustained commercialization of royal identity. While legal disputes with the British state remained active, those warnings were acknowledged but ignored. The result is an impasse defined not by access but by intent. Central to the Sussex response is the assertion that security concerns alone prevent a meaningful return. Yet, from the palace's perspective, this argument has lost credibility. Harry has been offered protection on a case-by-case basis for visits deemed necessary, but he has not accepted those terms, nor proposed a structured return tied to service, representation, or accountability. Instead, security is presented as a precondition for engagement rather than a consequence of it, a formulation the palace has rejected at every stage. By late 2025, patience had given way to policy. Senior aides confirmed that the institution concluded continued accommodation risked normalizing a dangerous precedent, allowing persistence and publicity to extract concessions where responsibility would not. The Court of Appeal ruling provided the legal foundation for that shift. The palace's statement provided the moral framing. Together, they replaced warning with boundary. "We are no longer negotiating behaviour," one official said privately. The Sussex strategy relies heavily on emotional appeal, particularly in international media markets, less familiar with Britain's constitutional framework. It can generate sympathy, but it does not rebuild trust within the UK. Polling conducted earlier in December indicated growing public support for a stricter, service-based monarchy. The ruling, far from provoking backlash, was widely viewed as overdue clarity for the palace. Public confidence is not sustained by appeasement, but by consistency. Perhaps the most consequential misunderstanding in the Sussex narrative is the suggestion that Harry was expelled. Palace records and the courts tell a different story. Harry was not removed. He stepped back. Security was not revoked capriciously. It was recalibrated lawfully. The institution did not close its doors. It refused to subsidise separation. By the close of 23 December 2025, the contours of the moment were unmistakable. A legal campaign that began in 2021 had reached its terminus. The Court of Appeal had spoken with finality. The government had aligned its policy with constitutional precedent, and the palace, for the first time in years, had articulated a doctrine with clarity rather than caution. This was not simply the end of Prince Harry's appeal, it was the reassertion of a service-based monarchy, one determined to draw a line between heritage and entitlement in public. The palace avoided triumphalism. No rebuttals to interviews, no counter-allegations, no personal denunciations. Instead, the official language emphasized closure, necessary finality, fairness, and public trust. This restraint was intentional. The aim was not to win an argument, but to stabilize a system. Senior aides described the outcome as overdue. Years of ambiguity had allowed grievance to masquerade as principle. The ruling replaced conjecture with structure. At its core, the conclusion was simple. Public protection is a public function. It exists to safeguard national representation, not to underwrite private lives. For King Charles III, the decision marked a defining moment of his reign. Faced with a choice between familial accommodation and constitutional clarity, he chose the latter. In doing so, he signalled a monarchy governed by rules rather than relationships. Advisers close to the king note that this alignment with law and government authority was deliberate. After a period in which the Crown's neutrality was questioned, Charles anchored the institution to process and precedent. The effect was immediate. Speculation receded, certainty returned. Equally significant was the unity among those tasked with guarding the monarchy's future. Princess Anne reinforced discipline. Prince William modelled authority through silence. Prince Edward upheld uniformity of policy. Catherine embodied continuity through service. Together, they presented a coherent front. The monarchy will not negotiate its foundations. The palace has not closed the door to reconciliation, but it has reframed the terms. Any future return, palace officials insist, must be grounded in responsibility rather than entitlement, and in service rather than symbolism. Security will not precede duty. Privilege cannot substitute for participation. National resources will not be deployed absent national purpose. This recalibration does not preclude family healing. It simply removes leverage from grievance within the United Kingdom. Reaction to the ruling underscored why the palace chose firmness. Public confidence, strained by years of dispute, responded positively to clarity. The perception that rules apply equally, even to those born into prominence, resonated. In that sense, the ruling achieved what accommodation could not. It stabilized legitimacy. As this six-part account concludes, the picture is resolved. The courts have closed the case. The government has affirmed policy. The monarchy has articulated principle. Prince Harry may continue to express dissatisfaction. He may continue to frame the outcome as injustice. But the institution has moved on, anchored to law, insulated by unity, and committed to a future in which service defines status. The crown has not expelled a son. It has reasserted a standard. And in doing so, it has made clear that in modern Britain, royal privilege ends where royal responsibility does. If you found this breakdown compelling, don't forget to like, subscribe, share, and comment below. Let us know your thoughts on this historic moment for the monarchy.